top next legal advocates and legal consultants. And also, sir is currently practicing as an advocate in the Delhi High Court. And he happens to be a very core IP enthusiast and also holds a great experience working on cases based on cyber laws, arbitration, real estate regulatory authority, demand and recovery forms, and other civil and criminal matters. Also, sir has industry experience in networking and testing from his previous knowledge that he obtained from his previous degree of BTech, everyone. It is indeed a great opportunity having you as our guest speaker, sir, because of your eminent knowledge in this field. On behalf of the faculty of and students of KD Society's Law College, I welcome you, sir, for today's session. The platform is yours, sir. Thank you so much.
Thanks, Athira, for the nice words. I think you have spoke a lot for me, and thank you for giving a wonderful speech and regarding me. Like to everyone over here, I was a student of this esteemed institution from 2012 to 2015. And it's been now 6 years down the line. I am into the practicing area in Delhi High Court, Supreme Court, and other several district courts of India. So yes, being into and being alumni of this esteemed institution, I have learned a lot. I had been taught by several lecturers, professors, principals, who are at present there in this college, and getting me and giving me the opportunity again, being from my alma mater, to present a topic, and even a topic like which is in general a hot one, and which will give you industry standard understanding how a copyright in general works out. So yes, I am also delighted. I am also happy to present myself before all of you. And without wasting more time, we shall start out. So Athira, can I start out, or like we have to wait more?
No, sir, please carry on, sir.
Sure. So I will be, sharing screen over here. I have made out a PPT. It will be more grateful to all of you to understand by the way of the PPT over here.
Yes, sir, sure.
Okay. Is my screen visible to everyone?
Yes, sir.
Okay, guys. So today's topic is for copyright. Copyright is under the ambit of intellectual property rights, and intellectual property rights have sub different heads. In total, I can call out 8 different heads IPR has, intellectual property right. So one is trademark, the another one is copyright, then patent, then geographical indication, then your designs, and then there are 3 more. So in total, there are 8 different heads. Today, we are just discussing a copyright. And even though in this particular of next 1 hour, I don't think so that I am able to include everything around the corner of the Copyright Act, because in actual, it is a very vast act. You have to understand in going into the deep, and I think so that by the way of my presentation, I am able to present everyone what exactly copyright means and what exactly it is. Okay, just a minute. So Indian copyright law is at equality with the global principles as contained in TRIPS. And as many of the students over here might be of last year or might be of first year. So if the students of first year, you guys wouldn't have much known about the the TRIPS agreements, the different agreements, the Berne conventions, and to all the treaties to which we are part of. So for which you first have to understand what is the convention, what is the TRIPS is all about, what is WIPO is all about. And for that, I have skipped out, because then this presentation will go into more into a theoretical concept instead of a, the case-to-case basis concept, which you can learn out being into a litigation part or being into a corporate sector. So that's why I have just given a gist of all these conventions and all these laws in only one slide. Later on, if any one of you want to know more about this thing, you can come back to me through the email address which the people over here can share out to you, even my phone numbers to you. So I can go further. The Indian Copyright Act 1957, as per amendments in 1999, 2002, and latest by in 2012. So it's been 9 years down the line. We had done the last amendment in 2012. And you know why the amendments takes place? The amendment takes place just because of the new laws came in picture, new understanding of the law. The legislature feel out that yes, there is a need of the amendment in the near future when you came across, or when you come across a new kind of challenges, a new kind of things which come across to you. So that's why you do the amendments. Still, being into the Copyright Act, being into the IPR field, I still feel out that there are few needs which has to be amended. The legislature has to look out that which all other things has to be amended out in this 2012 amendment. Okay, so going further, completely mirrors the Berne Convention for Protection of Literary and Artistic Work, 1886, and the Universal Copyrights Convention, to which India is a gathering. India is additionally involved with the Geneva Convention for the Protection of Rights of Producers of Phonograms, and is a functioning individual from the World Intellectual Property Organization, that is WIPO, and United Nations Educational, Scientific and Cultural Organization, UNESCO. So many of the people, who are enthusiasts of IPR, they know that what WIPO is, what WIPO exactly do, and many of the people even do the courses from WIPO. So for any one of you who is enthusiast into IPR, and which is a ever challenging and ever booming, area, and it will going to be in a near future also. So people go and do their general courses from WIPO. Moving on to the next slide. Just a minute. I think my okay. So copyright law in India is administered by Copyright Society. Sorry, by the Copyright Act 1957, which has been revised multiple times, with the latest alteration in 2012. As I told you in the previous slide, that the last alteration has been done in 2012. It is a far-reaching resolution accommodating copyright, moral rights, and neighboring rights. Okay, so privilege of broadcasting associations, entertainers, and droit de suite. The Act accommodates comprehensive financial rights in different work that are transferable. Moral rights exists in, and are vested in our creators and their legitimate agents, being non-transferable and enforceable by the creators and lawful delegates in any event when the copyright in the work has been allocated. So moral rights, as most of the people of you even know that what exactly is the moral rights, then under a copyright embed, there are several different rights which comes into the existence. One is moral right, another one is celebrity right. So then, the another one is your literary right, your artistic right. So there are some different heads which I have explained in the upcoming slides. So this will help you out how the moral rights is different from artistic right, from a literary right, from a celebrity right. Everything has a different definition over here. Now when there are there are act, subsequently there are rules, as if you go for a trademark, you go for a patent, or you go for a copyright. So there are rules for everything. The copyright rule 2013 came into power on 14th March 2013 and accommodate the system to be embraced for surrender of copyright, obligatory license, legal licenses, deliberate licenses, enrollment of copyright social orders, participation and organization of undertaking of copyright social orders, and entertainer social orders. Okay, I guess. Now, this has to be, on the very first slide, which I had kept on the third one, because I first want to know you that when had been the alterations has been done, when the amendments has been taken in place, what all the conventions and everything is over there, because I haven't went into the depth of this Bern conventions and other conventions. Instead of that, I had put on for what exactly the copyright is, that I put on the third slide. So copyright is a right given by the law to makers of abstract, dramatic, melodic, artistic work, makers of cinematograph, movies, sound chronicles. Actually, it is a bundle of rights including inter alia rights of reproduction, correspondence to the public, adaptation, translations of the work. There could be slight variations in the organization of rights relying upon the work. So if it seems to be, a problematic definition for you, I can make it into a more simple one. So copyright can be given to any of the abstract, a dramatic, a melodic, and an artistic work. Kind of. Suppose over here I am giving a lecture. Do I possess a copyright over this lecture? So for this, the section 53 defines that which all things are not under a copyrightable act. So over here, as I'm giving a lecture into a public domain, I cannot hold a copyright over here, because I also had gathered this information from the books, from the legislation, from the websites, from different platforms of the social media. So that's why I cannot hold a copyright over here, because this is not my work. This is not a new work. This is a work which is already, you know, uh, already accessible to many of the people, already into the public domain. So that's why which all things are not copyrightable, it is defined under section 53 of the Copyright Act. One can go and read out the section 53 of the Copyright Act and come to know that which all things are not under a Copyright Act. Okay, now comes to the terms of the Copyright Act. The general rule is that copyright lasts for 60 years. As the patent lasts for 20 years, trademark lasts for 10 years, the copyright lasts for 60 years. From the death of the author, whether it be literary, dramatical, musical, artistic work. Then from the date of publication, cinematographic films, sound recordings, photographs, post-Matthews publication, then works of government and international organizations. So one should be clear that till how much time period a copyright vests into a person. So that's what I'm telling you, that it vests for 60 years. Okay, now the registration of copyright and need of registration of copyright. So there is two different terminology. The one is that when you think of that there is a need of registration, and how do you do the registration? In India, the registration of copyright is not mandatory as the registration is treated as a mere recordal of a fact. The registration doesn't create or confer any new right and is not, perquisite for initiating action against infringement. Even though copyright is the only act, like as in trademark. So if you go for a trademark registration, if you have, registered your sound mark or your word mark or your collective mark, where you can, your sound and your word mark and your abstract, your text mark also. If there is an infringement for that, you can straight away go for the infringement, and you can go either for the passing off under section 134 or 135 of, Trademarks Act. Over here, if even though you wouldn't have done a copyright registration, still you have the power that you can initiate your infringement action against the culprit over there into the industry. You can go to the civil court. You can start out your, you can start out your actions against those people. So then the need of registration of copyright. The awareness of intellectual property right laws is considerably low among the enforcement authorities in India. And most of the IP litigation is confined to metropolitan cities. Despite the fact that the registration of copyright is not mandatory in India and is protectable through the International Copyright Order 1999, it is advisable to register the copyright, as the copyright registration certificate is accepted as a proof of ownership in courts and by police authorities and acted upon smoothly by them. So as I told you, that there is a thin line difference, that why you want to go for a registration and how you have to do a registration. So for how you have to do a registration, I can tell you that you have to go on ipindia.nic.in. While going to this website, you will come across the copyright subsection. Then there is a subsection for trademark. Earlier, there was a one particular website where you can go for the patents, trademark, and copyright now. And however, in 2014, somewhere around, the Copyright Authority had made out a different subsidiary. They had made out a different platform and a different website for copyright filing and infringement cases. So why you want to, registration of a copyright? Suppose if you go to a police station or you can go to a courtroom where you have to strengthen your case, where you have to show that yes, you are a copyright holder. So if you go for a copyright registration, this will give you a much more higher platform than a person who doesn't have a copyright registration in his or his firm name. So that's why it is always mandatory to go for a copyright registration, or else I can say, go for any kind of IP registration, whether it be trademark, patents, or copyright, or else for a design mark. So many of the people who don't even go for a trademark is very much, very much common amongst all. That yes, if I'm starting a new venture, if I'm into the industry, if I am an IP enthusiast, if I have to secure myself under the IP embed, I shall straight away, first of all, go for a trademark registration. Whereas people forget that they make out their social platform, which is the mandatory part for most of the ventures at today's period of time, where they have to make out a website. Without a social platform, they cannot exist into the market. So the moment you make out your website, there are several things which has to be looking after. I, being a computer science engineer, I know what are the complications while you make out the website, which all the things which you have to look after, how you have to strengthen yourself under the IP law, under the other laws where no one can do a cyber fraud with you. You have to make yourself compatible into the market. So while going for those things, one should go for a copyright registration of their URL that is Uniform Resource Locator. So once you go for a copyright registration, you can get the power into the market to sue others. Moving on to the next slide. So in Indian context, I can, this is for a general one, that the first act in 1914, followed by the Copyright Act 1957. Then in 1957, we had adopted many English provisions, introduced new ideas and concepts. Then we have introduced civil and criminal remedies against infringement. Earlier, there were no civil and criminal remedies against infringement, but now it is there. So if there is any infringement, there are, the kind of what I can say, the penalties on the wrongdoer are starting from 6 months to 3 years. So the moment it will enter into a 3 years time period frame, it is a non-cognizable offense, and where you have to be, you have to be ordered by the first class magistrate, and it will come under the civil code. Okay, so as I told you that when all the Copyright Amendment Acts came into the picture, so in 1983, Berne and Universal Copyright Conventions, the grant of compulsory license by developing countries, publication by deceased authors. So in 1983, the particular and the mandatory amendment which has been taken place under the Berne Convention was of granting of compulsory license. So this term compulsory license is very familiar in Copyright Act and in the Patents Act. If I talk about right now scenario, we are part of a challenging platform where the COVID has taken down everything. So over here, many of the countries are into the production of the vaccine. The moment you come under the production of a vaccine, you go for a patent of that. It will not come under the copyright, because a patent is always granted to a person which is new, which is not common, which is not available to the public domain. So you have to hold a priority date that is for a 1 year, and then you have. I'm so sorry if I'm mixing out copyright and patent, but being an enthusiast, I thought of to share and more knowledge to everyone so that you guys can be easily understandable for the things. Sorry to interrupt in between. Can anybody let me know that am I audible properly?
Yes, you're audible, sir.
And the screen sharing is also visible.
Yes, sir. Yes, sir. Everything is
Okay,
fine, sir.
okay, thank you. So when you go for a production of any of the what I can say pharmaceutical product, you have to go for a patent thing for that. So being into the patent industry, a registration of a patent and making of a new product, that will take number of years, number of months, number of powers of people, and so many things. So if we go for that, the people ask for the royalties, or if not for the royalty, they can ask for their part of money. So over here we go for a compulsory license of these kind of products. The similar things is eligible in the Copyright Act, where the compulsory license taken place. So that has been done in the 1983. Then in 1984, the discouraging and preventing widespread video piracy. As you know, still the video piracy are there. The latest film of Salman Khan. I am not a Salman Khan lover, but I'm just giving you an example. The latest film of Salman Khan, which has been published on, on Eid. So a case has been filed. I was a part of that case. I was not, arguing counsel, but yes, I was engaged. So I was that a particular case of that where G Media has filed out an infringement case against so many people before Delhi High Court, because a link has been circulated over the WhatsApp, over the Telegram, and over different other social media platform. The piracy of the film has been publicized before many of the people. So surprisingly, I'll tell you, there was a lot of people into the defendant side. Out of those defendant people, there are 10 of the people who are people like you and me, who are just circulating those links. So you yourself has to be a smart enough part. If a link has been come to you, and that yes, this is a forwarded link, but you know that this has been a factor of a piracy. Being a IP enthusiast and being into a law platform, one should be well versed with every law around the corner. If not into the deep practice, at least have a gist that what exactly the law speaks about. You should be aware enough. So if I would be on their place, I wouldn't have circulated to many more people, because then I will be the part of that video piracy. And that the similar thing one of the person had done. He had circulated that pirated link to several people, and that's why he had become a defendant to that particular case. Okay, moving forward to 1992, it defined the ambit of copyright, board's power, introducing special rights of performers and assignments and licenses of copyright, rights of copyright owners. So particularly according to, as I told you in the initial of starting of my slides and my lecture, I told you that according to time, the amendments take place. So the recent amendments, like very frequently had been taking place in 1983, 84, 1992, and the latest was in 2012. Okay, so limitation over here. Then we coming to the limitation part. Copyright protection is limited to the lifetime of the author plus 70 years after his death. So it's been not now 70, it's been 60. That was the first schedule of CAP LFN 2004. So 70 is in the case of cinematographic films, photography, sound recording, and broadcast. Whereas if you go for the artistic work, your literary work and other works, that is a 60 years. So this slide is talking about the provisions. I straight away, then jumped onto the provisions, the important provisions for which you should, remember. Though there are many, I have, jotted down into my daily notes for you guys to make more easily understandable. But over here, I have straight away jumped to the penal provisions, where you can, penalize anyone who can do the infringement of a copyright. So the Copyright Act 1957 has provided for enforcement of copyright through a series of penal provisions under Chapter 13. So there are in total 17 chapters. So no, not 17, I guess 15. So 13th chapter will talk about the penalization of what is is anybody asking something?
No, sir. Please continue, sir.
Okay, I'm so sorry. So out of these chapters, chapter 13 talks about the penalizing of a person whosoever do any kind of infringement. Under section 63, when any person knowingly infringes or abets infringement of the copyright in a work and any other right as covered by Copyright Act 1957, broadcast, reproduction rights, performance rights, moral rights, etc., such person may be punished with imprisonment of minimum term of 6 months to a maximum term of 3 years and a fine between 50,000 to 2 lakh rupees. Then section 65A penalizes circumvention of effective technological measures that may be applied to copies of work with the purpose of protecting any of the rights conferred under the act, copyright, performance right, and other rights. By virtue of newly inserted section 65A of the act, 65A is a newly inserted section. Earlier there was 63, 64, 65, which was for the infringement. And I can also say, I can tell you, section 51 straight away talks about how a copyright can be infringed. So these are the sections 60, starting from 63, how you can penalize one person, where all you can go, what all are the remedies available to you, but what are the things are infringed, that is defined under section 51 of the Copyright Act. Suppose you are a holder of a Copyright Act, what are the things which which can be shown to you that the infringement has been done, that can be done through section 51. Okay, then any person who circumvents an effective technological measures applied for the purpose of protecting rights conferred under the act with the intention of infringing such rights shall be punished with imprisonment that may extend to 2 years and would be liable to a fine. Similarly, section 65B provides that any person who removes or participates in the removal of right, management information, or the dissemination of copies of work from which rights management information has been removed shall be punished with imprisonment up to 2 years and shall also be liable to pay a fine. The Copyright Rules 2013 also provide for maintaining of records by a person permitted to circumvent technological measures as per the Act. So this is totally on the technological part. Section 65A talks about if there is any technology included into the infringement. So it is defined on the technological part. Section 65B makes unauthorized removal or alteration of rights management information punishable with imprisonment of up to 2 years and payment of a fine. The provision makes the unauthorized distribution, broadcast, or communication to the public of copies of the work punishable in the same manner if the person is aware that electronic right management information in the copy has been removed or altered. So, why I have inserted this section? As I have just given you an example of that Z Music had filed out a case. So they had gone into this section 65B of Copyright Act, where any broadcast or communication of the public copies, in an unauthorized manner, or there has been any removal or alteration of the data has been done. So one can be penalized under section 65B. Now coming to section 63A, that provides for enhanced penalty or second or subsequent convictions under the section 63. So if anybody is already convicted under section 63 and he is doing the similar kind of act again, that can be done under section 63A. So as I have told you that other provisions also talk about how the infringement of a computer program other possessing plates for the purpose of making infringement copies. There are several other sections, but over here I just emphasize on section 63 and 65. Rest you can go to your act and you can read out from over there, and if you face out any problem you can come back to me. Okay, now I have entered into several cases which make you understand, because copyright is a very vast area. As I told you that covers your moral rights, your personality rights, then your artistic right, your author right. So I had jotted down several cases for you people, which will help you out that how the cases are applicable in different scenario. So the first case which has been done into 1890, that was Macmillan and others versus Suresh Chandra, and it was of Kolkata court. So over here the court held that in the case of work not original in the proper sense of the term, but composed or compiled of prepared from materials which are open to all. As I told you, if over here I am giving you a lecture and somebody can uh, if somebody can take my PPT and start away giving out the same lectures to anybody else, I cannot claim for a copyright infringement over here. Though I can, but why I cannot? Because this is into a public domain. I am giving to all the participants. I have already publicized over the social media platform that I am going to deliver a lecture covering this such and such topics, and where I myself had taken out these information which is available into the public at large. I cannot claim for a copyright infringement over the people. Okay, moving further, the fact that one man has produced such a work doesn't take away from anyone else the right to produce another work of the same kind, and in doing so to use all the material open to him. But as the law is concisely stated by Hall in Hogg versus Scott, the true principle and all these cases in that the defendant is not at liberty to use or avail himself of the labor which the plaintiff has exerted for the purpose of producing his work, that is in fact is without amount to taking away a man's labor, or in other words his property. Thus anyone can use the publicly available materials to develop new ideas or caravans in doing new things by taking the assistance of the materials which are open to all. No question of copyright infringement will arise. So as I told you, if a thing is open to all, there is no infringement. The person who has invested labor and idea to create a new thing by taking resources available for open use will of course get the monopoly right over his creation. So yes, as I told you that if I want to, I can go, but I cannot go at large. Over here, my creation is, everybody know that many things is available through books, through social media, through other platforms. But creating this PPT, creating into a way, delivering a lecture into a way that I started from the convention. Then I told you that what the copyright exactly is. Then when all the amendments has been taken place, then I straight away jump to the the penalized sections, and now to the cases over here. So this is my labor which I've invested from last 2 days when I have been engaged by Manoj sir that I have to deliver lecture. So I have invested my time, my energy. Over here I can infringe, I can take the infringement action if anybody can do out the infringement part of my copyright delivering a lecture. Whereas if I'll go into the deep, I cannot go for, because this is available at large into a public. Now the next case law is Shamlal Paharia and another versus Gaya Prasad Gupta, that is of Allahabad Court in 1971. It has held that the expression literary work means not only such work which deal with any particular aspect of literature in prose and poetry, but also indicates that poetry indicates a work which is literary, that is anything in writing which could be said to come within the ambit of literary work. So what is a literary work? If any poetry or a prose as in like you write down few lines or you do a poetry part, so that is a literary part. A compilation delivered from a common source falls within the ambit of literary work. In this case, the mistake appearing in the plaintiff's book were also appearing in the defendant's book. And commenting on that aspect of the case, it was held that it was true that a mere fact that the defendant had the plaintiff's book with him will not by itself lead to an irresistible inference that he had copied the calculations from the plaintiff's work. But from the fact that the mistakes committed by the plaintiff in creation calculations in his book were found in the defendant's book in the similar calculations clearly shows that the defendant had copied the calculations from the plaintiff's book. So what has exactly happened, in this Shamlal Paria, he had written down a book. He has done few calculation mistake over there. Then the Gya Prasad Gupta had also write down a similar kind of book. So suppose if you go for, I can take out example of a Hindu law. There are several authors, there are several books into the market where you can go and you read out. So many of the, because then the legislation and the legislature has made out the law applicable same to everyone. So suppose into a copyright act or into a Hindu act, which I am giving you an example. If you are deliberating, if you are, if you are writing down any particular section, suppose if you writing down a section of section 51 of copyright infringement into a copyright, if you are an author, if you're writing down a book, you have to write down the similar act, whereas you are defining the legislature. The moment you come into the explanation part, the explanation may differ from the plaintiff to defendant. If I am also author, you guys also are author. The moment you come to an explanation part, you explain in your own way, I explain in my own way. If you copied the same, then it is an infringement. The same has been done in this particular case. If you write down and give a different kind of submission, that is not an infringement. So the division bench, accepting the verdict of the single judge, held that the same arrangement has to continue. And just a minute. Yeah, okay. As to continue, and the defendant were entitled to sell their CD-ROMs with the text of the judgment of Supreme Court along with their own head notes, which should not in any way be copy of the head notes and text belonging to the plaintiff's work. So I'm so sorry, this is not similar to the previous one. I had given a heading to this that has been omitted out. I don't know how and why, but I will let you know the case. This is only a brief fact of this particular case. I'll let you know the citing of this particular case at the end of my PPT. Now this is the another case, Gramophone Company of India Limited versus Brendra Bahadur Pandey and others. That has been done in 1984. Special features of this case are that it deals with the right of the owner of copyright to stop the infringing copies from being transmitted to another country. So this is a very important case, why I put it over here. You can find n number of cases, but what I tried to do out that in this particular 1 hour of session, I may deal with different particular scenarios. So I can come to over here. This is, section, just a minute. Yeah, section 40. So section 40, okay. Section 40 will give you a power to extend copyright to foreign works. So section 40 of a Copyright Act will allow you where you can, if there is any foreign work which is already been, copyrighted in any other country, or which you have done in your country and you have to make it a copyright in other countries, then you have to be a part of the conventions. That is number one. And this was a landmark case where, the right of the owner for infringing copies from being transmitted to another country. So what happened is, like, Gramophone Company of India Limited, they were the plaintiff over here, and Brendra Bahadur Pandey and others, what have they have done, that they were selling out these copies to another country. So you can sue them in India itself, because you had done your you had originated your work and you have your copyright mark, what I can say, a certificate in India. So then again, the Gramophone Company of India versus Super Cassette Industries Limited. On an examination of the facts of the case, it was decided by the courts that the injunction that was awarded in favor of the plaintiff should be set aside by the act permitted version recording, and the defendants were permitted to record the music subject to the condition that it should not use the cartoon or inlay card or any other packing material similar to that of the plaintiffs, and an alternate title must be given with the declaration in sufficiently bold letters that the record is not the original soundtrack but only a version record with voices of different artists. The word that is not the original work should be clearly underlined. This is the another case of gramophone company. This is the very big company which go into the sound recording. So super cassette industry recorded, they are also into the sound recordings. What happened over here is, I can give you the people would have read out this the facts of this case. Now I can give you another example. There are always a remixing of things go on. So what happened exactly when you come into, yeah, suppose in 1975 the Sholay movie came. There were the initial songs were there. Then again after 25 years, sorry, after 50 years, the color movie came. Earlier it was not into that much of colorful way. Again after the 50 years of the production of that movie, 75, that not 50, sorry, that was only, yeah, 35 years, yes, it came recently. So if 75 to, it came recently. So where after the 40 or 35 years of production, again a colored movie came out. The songs were tracked into a new soundtracks. A new person have came out, so they had taken a license from the previous of the producer and other people, and then they had again started out doing a remixing part, or again doing the labeling or a recording of the sounds. So while you do out the labeling, in this particular case the court had given they have set aside the injunction which has been granted in the favor of gramophone initially, but they had set aside the injunction with the further implications, with the further guidelines, that you have to given in bold that this is not a new creation, this is only a remixing, or only a new version of recording, where you can record out by taking a permission from the initial owner of that recording. So the same similar has happened into the example which I am giving for the Sholay movie. You have to first take the permission from the owner. If yes, you are paying a royalty, of course. Without money, nothing exists. If you can go pay out the royalty to the first owner, definitely he can give you the permission, and then there will be no infringement case. I think I have to, cover up very soon because I have so many slides. As I told you that I tried to be cut short, but then I had made out 30 slides in total, and I think I am on just only on the 10th slide as of now. So, okay, the PepsiCo company and others versus Hindustan Coca-Cola and others. That is a 2001 case. In this case, the issue of copyright protection for advertising slogans was considered. The Delhi High Court held in this case that the slogans are not prima facie protectable under the Copyright Act. They may be protected under the law of passing off. Here the plaintiff makes out such a case. So as I told you, a passing off is another terminology where, if nothing is confined under any of the act, like suppose in a trademark or in a copyright act, then you can go in under the passing off. Passing off is a terminology that's similar kind of. So the slogans which the PepsiCo and Hindustan Coca-Cola, like at that time, Dil Mange More and all those things in 2001. So I know I was in, I think, 10th standard at that time, and Hindustan Coca-Cola has taken the same slogans. So that came into the passing off instead of infringement case. Okay, when sound recording, just a minute, this is remix and these were the cases which I've jotted down. Now remix and copyright law. Right now, as you aware that in many of the movies, only the remixing of the previous songs are coming out. No new songs are coming out. Now the era has come into a picture where many of the sound producers, or the film producers, they want the old songs into a new remix one. So what exactly the things over here applicable for them? When sound recording is done, of some additional elements added with some different music or beats, then it becomes remix of the original song. So this is a kind of a definition which I want to give you over here, the what exactly the remixing of a song is. Then the work created by the remix will consider new work or modifications to the old version. Even though the new work is somewhat different from the original work, the author is required to obtain a license from the owner of the original work. There is no specific provision or process is given under the Copyright Act for obtaining a license for remix work, as it is given for cover version work. So in my another slide, you will come to know what is cover version is. Okay, remix and cover. The difference between the remix and a cover. The remix is used in a production context where reconstruction is made by adding effects, edits, DAWs. DAWs are digital audio workstations, etc. The remix is totally different from the original work, different harmony, structure, etc. Remix performers tend to perform with the original author is work presentation, whereas the cover is often used in a band context where one singer performs with another artist. You know, the people who are into the band part, like who do the real shows, the reality shows, there will be a band group behind them, so they come under the cover. So this is the thing which you will not come to know while you can read out your textbooks, which is the old fashion, which I must not say, but I don't know, BC, like Bar Council of India, BCI has to look after that. They should do the amendment part where they can, instead of giving more uh, theoretical part, they can give the more structural part, as in where people can visit the courtrooms, they can read out the ongoing scenarios of the particular cases, so they can come to know how to relate the exact things, the exact platform with the theoretical part. So the cover exists with the band people who do the live performance. The cover consists of almost all the same elements which are in original work, whereas cover performance tends to replace the original author from work presentation. Musical work is defined under Section 2P of the Copyright Act to include a work consisting of music and other includes graphical notations of such work, but it doesn't include any word or an action that is intended to be sung, spoken, or performed with the music. In Gramophone Company of India versus Super Cassette Industries Limited, the Delhi High Court observed musical work is not merely a combination of melody or harmony, or either of them. Every musical composition has a structure or shape, that is arrangement of individual element as to constitute a whole, and the musical notation means a visual instructions for performance of music. So when you are a lawyer and you are into the IP embed, and if you are doing your individual practice and you are getting a client, and a person is from a recording industry, you should be well versed with the musical notation. You should know how to read out a musical notation. In my last 6 years of experience, I had been across to several things, and daily is a learning platform for me. I recently learned how to read out a musical notation. The moment you don't know how to read out a musical notation, you cannot present yourself, either it's from a plaintiff side or a defendant side, into the courtroom. You're not able to, make the judge understand that how it is different, how the music notations are being influenced by the plaintiff or by the defendant of your musical notations. Okay, so moving further, the Copyright Act also protects the adaptation of musical work, which means that it protects any arrangement or transcription or to a musical work. An owner of a sound recording is promised creation rights through Section 40E of the Copyright Act. This includes the right to make any other sound recordable, embedding it, the right to sell, to give on hire, or offer for sale or hire any copy of sound recording, whether the same has been sold or hired in the past, and the right to communicate to sound recording to the public at large. The worrying things apart, just a minute. Okay. The worrying things apart about this scenario is that so much of our normal everyday behavior puts up at the risk of infringement copyright, as much of our life is digital. To quote Professor Ein, Hargreaves, the copyright regime cannot be considered fit for the digital age when millions of citizens are in daily breach of copyright. Yes, we are in, daily breach of copyright in a small piece or another. Initially, this Spotify, then your Wink Music, what they have come, they had come under the platform that they had given you several songs, and Spotify haven't, though this I forget the name, but Spotify initially they forget to take the license from the people and from the original makers of these songs or the licensee of these songs. So a copyright case has been filed out against them that they haven't paid out the royalty. So as I told you, the section 52(1)(j) of the Copyright Act states wouldn't count as an infringement if there exists a sound recording of the original literary or musical work and the person who wishes to copy it has been given a due notice of his intention to use it and make a sound recording, has also paid the original owner the royalty price that has been fixed by the Copyright Board. Okay, coming to, I'm less with time and I have several sites to cover upon. So just bear with me. The person wanting to make the remix cannot make alteration without taking the consent of the owner or cannot make changes which are not reasonably necessary for the adaptation of the work. Okay, as I can give you the latest example of a song of where the Varun Dhawan, I think initial song was of where Salman Khan was in movie. I really forget the name of that movie because I'm not that much enthusiast of watching out the movies and particularly of Salman Khan. I'm so sorry if I'm defaming anybody's who is a diehard fan of Salman Khan, but I'm not. So over here, I'm just trying to give you an example. Uh, I forget the name of the picture. I just give you an example where the two people who do the same character of Salman Khan in the initial movie and then now the Varun Dhawan. So the same songs has been made out over here, but those were the remix, and those remix songs would have taken the permission from the initial, the copyright holder of that original song, and then they had been permitted that which all things they can do out as a remix or as an alteration over here. The new sound recording should not be marketed with the labels or packaging that might mislead the public about the identity of the artist. This is very much, important over here. So if you sell out into the market, the labeling and the marketing will not be done, of by passing off the original owner of that song. The original owner has the right to inspect all records and books related to the remix. The consent of the owner of the original song is of great importance as the original sound recording was created by him and he enjoys the exclusive right of ownership. So over here, the ownership will fall under the original owner, not the person who has taken the, who has taken the permission from the original owner. Then section 52(1)(j) states that the work like music and sound recording are subject to seeking permission from the owner of the copyright for certain uses and changes. This acts as legal authorization to use the copyright work in creation way as long as the user pays the required fee and otherwise meets the conditions in the laws. Okay, so I think just a minute. Okay, so this one is the last slide. Oh, hopefully I am able to complete my version in just 1 hour of time period. So Copyright Act 1957 along with the Copyright Rules 1958 and the amendments thereof intended to protect the rights and interests of the creators, owners of the intellectual property, as well as protecting the interests of the world at large. It is to be noted that the Act is a full comprehensive regulation which stands on a pillar that the works of the owner shall not be stolen. Over here, what the copyright or any act of the IP speaks about, the protection of the owner. This act is drafted in consonance with the English and the American intellectual property laws. This act is determined to provide safeguards of the owner as well as the work In India, copyright is considered as an architectural work which will subsist only if the work is located in the country of its origin, that is India. So, that this is my last slide. And before, concluding, I just want to briefly explain you some other things and then I can conclude. Being an IP enthusiast, one should start with a WIPO course, which was, my mentors, my seniors has told me when I was into my law school, and I was, reading out the different case laws every day. The major drawback to me, I'm so sorry if I'm, putting out this thing, there should be one language bar throughout the India in the district court. The major drawback which I faced out being into the Karnataka, not being a Kannadiga, I was not able to understand the Karnataka language, the Kannadiga language. I used to visit the lower courts. The people communicate over there, and it's not only for Karnataka, it's for Punjab, for Maharashtra, for Tamil Nadu, for several things, for several other not things. I'm so sorry, for several other states. In district courts, they communicate in their own regional language. So it was so harsh and so problematic for me to understand the local language. So I used to visit to high courts, and being visiting to high court, you have to make out the passes. I was not known to anybody over here, and that was the major drawback, that being into my law school, I missed out my the practical knowledge being visiting to the different courtrooms. So that's what I, being as a layman into this country, everybody has a right to say their whatever they think of. So this, I think, that being into, either it be the district court, or either it be the high court or the Supreme Court, English should be the language at bar, or at par, where and everybody can understand the language, and they would gain more and more practical knowledge instead of the theoretical knowledge. So yes, over here, being into the copyright, it is very vast. The main sections and the main amendments which I can tell you in 2012 taken place was section 18 and 19. So trust me, guys, and go with me. Read out section 18 and 19. These were the two sections which got amended in section in 2012, because of which the original owners was about to get the royalty for their part. Prior to this, there were no royalty factor. Nobody, it was, the royalties were not given. It was person to person basis. After the amendment of this act at the section 18 and 19 2012, the person used to get the royalty of their original work. Then section 631 speaks about the compulsory license, which I talk about. Compulsory license will fall under circumstances, certain circumstances where a compulsory license has to be provided. So one can go and read out section 31. He can come to know what is the compulsory licenses. Then section 32 speaks about the termination of a copyright license. If anybody would have got the license, how can be terminated? That is discussed in section 32. Section 40 is for extending the copyright to foreign works. Then the 51 is talking about the infringement, 52 non-infringement, and section 55 gives you the civil remedies. After this, there are different copyright boards which people doesn't know. They just read out this thing, and if you are not a IP enthusiast, and if you are not practicing under IP law, still you should be aware that there are different boards. The recent case between Delhi High Court was regarding the PPL board. So there are 5 boards in total, and after 2012 amendment, these boards has to register themselves. They again have to register themselves before the copyright society. So these are the boards oblique societies. So there are 5 copyright societies, and in practice there are 3 as of now. That is IRRO, ISRA, Script. IPRS and PPL are under the challenge. They are still struggling out. They had recently filed out the case. So PPL and IPRS, if you go through Indian, Indian publication, IPRS has a different definition. So one, you can go through different case laws. You can come across that IPRS name is at different places. These are the societies which haven't registered themselves, and these are the societies which give license to many of the people. Now, not least, but the last over here is to conclude my thing. People don't even know that to run out a live show, to run out a DJ night, and to run out a place where you have to sing songs or where you can play songs, you still have to take a license. In India, as we are living in a country where there are, the population is too large, and the legislatures and the lawmakers are not that much into a number. If I talk about the per capita, they are not that much that they look after everything. Otherwise, if you would be into a small town and if you play out a DJ, or you play out a live performance without taking the permission from these copyright societies, you will be infringed. Many of the people doesn't know about this thing. So me being a lawyer, if to my any particular activity or to my any particular program, if I'll go for a for a DJ night or something, I will be sound and bound myself with the laws. I'll take out these permissions from these societies and these boards, so that nobody can come and sue me for any other thing. So that's it, guys. If over here I can conclude, and stop sharing my uh, I stop sharing my PPT over here. Just a minute, I'm coming back to. Okay. So that's it, guys. That's it for today's lecture. I guess I am able to give you understandable lecture by the way of this presentation. But still, if you guys have any kind of query, if you guys want any kind of practicing platform or a helping hand from me, you guys can straight away come to me, and you can contact to me over my email address, and you can find me over my LinkedIn. And sir is there, Manoj sir is there, and Simona is there. They guys can help you out. So any question, because I am end with my PPT of the day. I am
Yes,
ready for
sir.
the questions.
Thank you so much for the very enlightening session. So we actually have two questions here. That
Okay.
is, the first one is, sir, can you please put some light on the first topic that is asked by Mahabalesh, is that protection of traditional knowledge like folks, etc., under the existing copyright regimen in India. And the second one happens to be the efficacy of Indian copyright law in this digital era. That is what Mahabalesh is asking you to throw some light on, sir.
Yeah. Just I have went through the chat box and I'm reading out protection of traditional knowledge like Fox, etc., under existing copyright regime in India. Yeah. So, brother, if you want to, go for the Fox tradition, it's already been registered out. It's already been got the copyright. The folk tradition, if I'll talk about, yeah, and being into the northeast side, they do the traditional work over there. They had already taken a copyright protection through the Copyright Act. Go to ipindia.nic.in, and you will come to know that who all have got the copyright protection. So the next one, the efficacy of Indian copyright law in the digital era. Yeah, that's too much. So in the digital era, as I told you at the initial of starting of my of my PPT, suppose you are entering into a new venture and you made out your website, you definitely has to go for a copyright protection of your URL, that is Uniform Resource Locator. Suppose that is xyz.com or .in or .org. Go for a protection of that. And if anybody in the near future use the same URL, you can straight away go for a copyright infringement, as you have registered yourself your URL under the copyright protection. That is number one. Then the number second will be you can protect yourself under the other challenges like from the cyber fraud and other platforms. So there is one technical term which is SSL. So people can go, being me a BTech grad, and as of now, when there was a lockdown, I was developing a website for one of my client. So he needs a total platform from me, the website development and the law part also. So I had been into the SSL part. taken a SSL feature, nobody can easily break down your website, your URL, or they can infringe your platform. I think I am able to clear out your doubt. His name is
Abalesh, sir.
Mahabalesh. Okay, Mr. Patil,
So,
I think I am able to clear out your doubts.
so the next question is from Akshat Kumar Jain. So,
Okay.
Akshat's question is how to prevent misuse of jurisdictional issue related to infringement of copyright with respect to selling of products on internet, sir.
This is a very interesting question. So, the jurisdictional issue has to be looking after. As I told you, the Z Music, though Z Music held in Mumbai, they have their registered offices in Mumbai, not in Delhi. But hence, the infringement has been taken place in Delhi. That's why they had filed out a case in Delhi itself. So, jurisdictional issue has to be there, and it doesn't mean that that can give you more challenging platform into engaging a lawyer. If you are supposed to be in south of India and the infringement has been taken place in North India, then you are not that much comfortable traveling to North India instead of being filing out a case in South India. But yes, the jurisdictional issue is there, so you have to make out and file out a case according to the jurisdiction of the cases. So that has to be looking after. The recent example of the Z Music I have given to you. Instead of filing out the case in Mumbai, they had come down to Delhi and they have to engage the lawyer over here, and they had engaged Amit Sibal for this particular case. So Amit Sibal was, fighting out this case over here. Okay. Any other question?
Sir, I had a very basic question. So it's all about the licenses agreement and assignment agreement that comes into cinematographic rights, sir. So can you please throw some light upon the same, the two types of agreements that basically comes under, cinematographic rights?
This question has been done by it's is it into the chat box? If I
No,
can
it's
figure
my
out.
question, sir.
Okay,
It's my
okay,
question.
okay. Come again, come again.
So my question basically is, can you throw some light upon the difference between licenses agreement and assignments agreement in relation to cinematographic rights?
Okay, license agreement and another agreement which you're talking about. So
Indeed, sir.
yeah, okay. So being into the license agreement over here, the license agreement, the licensee over here makes you a licensor, and he will give you for a particular time period. Particular time period, he will given you uh, with the the kinds of the pointers that this you have to look after, this you have to do out. So this will be under the license one. And the another one which you are talking about, can you please come again, the another term which you said?
Assignments agreement, sir.
Assignments, yeah. So being into the assignments one, he assigned you as in you might be a part of where you can you have you go to that mere the producer of that particular cinematographic film or any particular act or a short film. So you went to that producer, and he had assigned you that thing, that you might be a part of the royalty which will come from the production of that particular part. So you will be the part of that royalty over here.
Okay, sir. Thank you so much. We don't have any more questions. So I invite Manu to basically give the vote of thanks.
Sure.
Thank you, Adira. I hope I'm audible. A
Yes,
very good
Manu.
morning to everyone. It's my privilege to have been asked to propose the vote of thanks in this particular occasion.
Manu,
Firstly,
can you please little bit louder? Your voice is not audible.
is it audible now, sir?
Yes, it's audible now.
Yes. Thank you, sir.
So I can give you one thing. In my previous lecture, I was also facing the same problem. I had taken out these headphones, and all the time I have to put my hand near to my mouth. So this time I haven't put out any of the headphones over here. Anyways, go ahead.
Yes, sir. Thank you, sir. Firstly, I would like to thank our special lecturer, our beloved guest speaker, Advocate Ramit Rana, on behalf of our college and the entire fraternity of this institute. So, as you have already mentioned at the beginning of this lecture, final year students are also listening in. And being one of them, I can assure you that a considerable chunk of them are looking forward to building their career on IP laws and IP sector. And I sincerely hope that your talk would act as a stepping stone for them in their future. And for that, Thank you again, sir. Further, I would like to thank Dr. J. Mallikarjunaya, our beloved principal, sir, for providing us with this platform for these special lectures, which has been rather informative. And also, I would like to thank Dr. and Professor Manoj Kumar V. Hiremat, the IQAC coordinator, who has been vital in organizing these special lectures. Moving on, I would like to also thank Ms. Simona Wahid, the faculty coordinator, and also the members of the organizing team. Finally, a huge thanks to the faculty members and, of course, the students who had tuned in to attend this lecture. And I sincerely believe it has been helpful. Thank you again, sir. Thank you, everyone. Have a nice day.
So before ending up, I just want to thank
you. Thank you, Ramit. Thank you very much for taking out your time, sharing your practical experience.
Thank you so much, sir. And before concluding